Good afternoon. Welcome to our webinar on immigration options for highly skilled employees. My name is Mike Stroster. My partner, Ewelina Sawicka, is tuning in remotely from home, I think. And we're going to take you through in fine detail, the immigration options that are available for those foreign nationals that you might find or maybe already have at another location who are highly skilled, and let you know what the options are for getting them to the United States, and then, of course, keeping them here. There are immigration options that are available for any type of employer and any type of employment. They span the spectrum from physical labor to research science. And the United States immigration system is designed to allow U.S. employers to employ foreign nationals in any of those jobs. But there are very important differences in the process and the timing. And timing is a critical issue for all of these situations. Our system is designed to favor those who either have advanced formal education or those who have ascended to the pinnacle of their field, whatever that field may be, and we can demonstrate that they are among the very highest elite members of their field. Our system says that the United States employers, or the United States in general, wants those folks living and working in the United States for all of the obvious reasons. We're going to focus today on those visas that are available to those who have those advanced formal education qualifications, or who have advanced to the top of their field. Again, a lot of other options available for, from physical labor landscapers. There are visas available for those, all the way over to cancer research physicians and those. We're gonna focus today on this end of the spectrum. So in front of you is the slide on the specific topics we're going to cover. If you have questions while we're going along, please put them in the Q&A tab on the presentation, and we will answer as many of those as we can. So we're going to start, because visas in the United States are divided into two primary categories: non-immigrant visas, which are temporary, and though they can be valid for a long period of time, 6, 7 years, sometimes longer, very different than immigrant visas, which are, of course, permanent, or where we get lawful permanent residence from. So we're going to cover both based on employment, but we're going to start with the non-immigrant visas. And the primary non-immigrant visa available for those individuals who have extraordinary ability or achievement is the O1 visa. The O1 really is just a reference to the portion of the federal law that enacted it. Doesn't really mean anything other than it tells us what category of visa that we're dealing with. But for O1 visas, those are available to those who can show extraordinary ability in the sciences, arts, education, business, or athletics. And those are pretty broad categories and are treated pretty broadly by the Department of Homeland Security. And so the takeaway that I'd like for you is to use your creativity and imagination, as you might when you're thinking about the types of candidates that you would have that might fit in the sciences, business, education, or arts. Arts actually means arts. Athletics, obviously, that means something. But business and science, those are two areas that are very broad, and we can often fit all sorts of particular job titles or job classifications into one of those categories. There are two different visas. The O1A is for the science, education, business, and athletics. The O1B are for those people who might be involved in movies or television. And what we have to do in order to take advantage of the O1 visa is we have to show through documentation that an individual candidate has extraordinary ability or has already gained extraordinary achievement. And we have to do that, like I said, through documentation. They won't simply take our word for it. And there are a number of ways that we try to do that. The first requirement is we need some evaluation from a peer group, a labor union, or some other relevant organization to confirm it, meaning it's essentially the equivalent of an expert opinion by somebody who can qualify as an expert in whatever category it is that we're working on. And that can say that I've reviewed this individual's qualifications, and based on my expert opinion, this person has extraordinary ability in their field. That's a entry-level requirement into the O, and that might sound like a significant hurdle to get over. It is really achievable. We have access to a whole host of peer groups that are familiar with this process and are willing to evaluate somebody's qualifications and issue an expert opinion. So that is something that is fairly easily accomplished. What's a little more challenging to accomplish in a lot of cases is the proof of eligibility under these other certain criteria. And we have to show that in order to qualify for an O1, a person can demonstrate, again, through documentation, that they have achieved at least 3 of the different categories of qualification. Those categories include the receipt of national or international awards, membership in an organization that requires outstanding achievement to be a member, publication of materials about the individual, meaning news articles not by the person, but written about that person's work. If they've acted as a judge of the work of others in the field, that's very good evidence that they've ascended to the top of their field. Of course, we can show original scientific work, publication of scholarly articles, or that they've been employed by an important employer in the United States. Ewelina and I are going to have a call actually this afternoon with somebody who just accepted employment at Harvard Medical School. And it's going to be really simple for us to sort of stand on their shoulders and demonstrate that if the Harvard Medical School hired this person, that they must have achieved extraordinary achievement in their field. And then the last category that we have to or we can show is that the person commanded a high salary relative to those in the field. So we take all of those, and if we can demonstrate through documents that the person can meet 3 of those criteria, then generally they're going to qualify for an O1 visa. How do we demonstrate those things? We can do it through documentation of an award received, proof of membership in one of those groups. We can do it through affidavits by people in the business if they're familiar with the person's qualifications, or any other documentation that we can provide to the agency that shows that they have actually, in fact, achieved these things. Of course, in this case, different from some of the other visas, the O1 has to be based on a job offer in the United States. So it is the employer's application on behalf of the employee. That's not always the case with some of these high achieving folks. And so the application for the O1 comes after the job offer is made. Other visa categories that we'll talk about today, the individual can self-petition, meaning they don't even need to have a job offer, but frankly, they can demonstrate that they're so skilled, so highly skilled, that the United States, as a matter of policy, would want them in the country in order to engage in their field, whatever that field might be. Of course, foreign nationals can bring their spouses and minor dependents with them. You can see at the bottom there, the O2 visa is available so that those folks can join the O1 visa holder in the United States. They are not authorized to work. Some other types of dependent visas come with employment authorization, but the O1 is not one of them. So what are some of the types of positions that we can use the O1 for? Physicians, obviously, executives, research scientists are frankly the easiest, because I think it's easiest to show what they've done through documentation. They're always publishing articles. They're recognized in journals that are dedicated to following the work that they're doing. So researchers really of any type are really relatively straightforward and really finely attuned to the O1. Engineers, if you have an engineering candidate of any kind for an engineering role in the United States, we're going to be able to make that happen. The O is a great category for engineers who, again, though have achieved something in their field. Recent graduates, whether it's at the bachelor's level or the master's level, generally are not going to qualify for O visa classification. They will, of course, qualify for the H-1B if you're familiar with that at all, or the TN visa if you're familiar with that. So there are options to get those engineers in who may be recent grads, but those who have been working in the field and who have accomplished significant things in their careers, the O1 is a great option. Athletes, again, athletes who have already accomplished things in their field, in their career, in their league. We have the Olympics coming up, and when they're in the United States, I know they're in Paris in 100 days, but when they're in the United States, O1 is a great way to get somebody into the United States to participate in that, and get their coaches. I'm getting ahead of myself a little bit because there are visas available specifically for those folks. But I pointed out because anybody where we can demonstrate there is a field and somebody has attained some level of notoriety in that field, we can make it happen, including executive chefs and brand ambassadors, which is a great category these days, certainly with social media. I got ahead of myself a little bit relative to the athletes. There is a specific visa category that is available for athletes. You can see the criteria for them right there in front of you. We bring this up because we have a couple of people attending today that might find this very relevant to what they're doing. Certainly this applies at the highest level, but it also applies at the minor league level. So it applies equally to the Detroit Red Wings and the Grand Rapids Griffins, or the Tigers and the West Michigan Whitecaps. So long as those folks have achieved and essentially achieved something in their field, and essentially that determination is left up to leagues if they're involved in a athletic endeavor that has a league or a players union, those folks can provide the expert opinion that shows that they should be allowed to enter the United States to engage in their craft. It also includes theatrical ice skaters. I think Disney on Ice must have got that exception added specifically for their own purposes, but I've enjoyed Disney on Ice many times with my kids, so I'm glad that they did it. Very similarly, we have to provide written consultation and documentation that shows that these folks have ascended in their field. They can't self-petition. They need a U.S. sponsor. Oftentimes, those U.S. sponsors are going to be leagues, or in the case of Olympic events, it'll be the U.S. Athletic Association dedicated to that particular event. Spouses can come, dependents can come as well. And then, interestingly, there is another subcategory available for coaches, trainers, interpreters, and all the other people that are involved that make something athletic competition at the highest level go. There are visas available for all of those folks because at the end of the day, we want those folks here in the States. So that's it on athletes. What is going to apply to more broadly to the folks who are on this webinar, though, are visas that are available for those folks who work at any of your foreign affiliates if you have operations outside of the United States. And Ewelina is going to take us through some of those.
So like Mike said, I will be discussing the L1 visa, which is a great option if you are a multinational company seeking to transfer employees from abroad to a U.S. affiliate, branch, subsidiary, or your parent company. In this context, multinational basically means that you have your U.S. entity that will serve as the petitioner and at least one entity abroad. Generally, it's the entity from which the employee is being transferred over from. When it comes to the L1A, there's kind of two prongs of eligibility. First, we have to show that the entity, so both the entity in the US and the entity abroad are qualified. And then we have to show that the employee is also qualified as an executive, manager, or in a specialized knowledge position. So just very quickly, when it comes to the entity, what we have to show is first that qualifying relationship. So we have to show that the foreign company and the US company are a branch, affiliate, or subsidiary of the other. And we have to provide documentation of that. And then the second thing is we have to show that both are doing business. So it's not enough that one of the companies, for example, is a holding company or something like that. They both have to be doing business. They can be both held by the same holding company, but the two that we're showing the relationship between have to be the ones that are actually doing business in their country, in their region, whatever it may be. And then I will talk about the second prong, the employee eligibility, on the next couple slides. But just a few more things off of this slide is that I just wanted to briefly go over is blanket L certification. So this is great for entities that are a little bit bigger, that have at least, you have the U.S. petitioner and at least 3 other related entities. And those can be domestic or foreign, but at least one of them has to be foreign. And who have U.S. sales of 25 million or 1,000 U.S. employees, or have had 10 L1s approved in the last 12-month period. So what's really nice about the blanket L for those bigger entities is that if your entity qualifies for the blanket L, with each applicant that we have, we do not have to prove that qualifying relationship again. We just have to prove it that one time for the blanket, and then later on, we just have to show that the employee himself or herself is qualified. And that can actually be done directly to the consulate. It does not have to go through USCIS, the internal agency. So that's a little bit about the blanket, and we're happy to evaluate whether your company could be eligible for it, because it is a nice quick option later on. And then also the L1 is also good for companies abroad that are trying to open a new office in the United States and sending a foreign employee who qualifies as a manager, executive, or specialized knowledge to the United States to open that company. So there's lots of options underneath the L1A, and that's on the entity side. With the second prong, so eligibility, as a manager or an executive, that's an L1A. For these individuals, we would show that your applicant, your candidate is either a personnel manager, a functional manager, or an executive. I have briefly on here the definitions of those, but just very quickly, a personnel manager is someone who has direct reports, controls their work, and generally these are individuals in supervisory, professional, or other management employees. In the immigration context, professional means that they have at least a bachelor's degree. So those are the kind of individuals that this manager would be overseeing. Another manager would be a functional manager. So it's someone who oversees a central function to your company or a specific department or a subdivision. They don't necessarily have direct reports or don't have direct reports that qualify under that supervisory, professional, or manager categories. But they still manage a very important function to your company. Those can qualify as well. We just have to provide a little bit more documentation about the specific function that they are overseeing. Another thing about both managers, though, is even if you're a functional manager and don't necessarily directly manage people, generally what USCIS wants to see is that there's some kind of authority over decisions. So decisions such as hiring, firing, compensation, promotions, that's something that with both of those categories, they still generally want to see. And then an executive is someone who directs the general management of the organization. These would be your VPs, the CEOs, COOs. This is a great category to transfer individuals between an entity abroad and an entity in the United States. Some other requirements, there's no degree requirement for the L1A, but we do have to show that that person has been working for the affiliate company abroad for at least 1 year out of the last 3. And this can be in either a manager position, an executive position, or a specialized knowledge position. So it doesn't have to be a manager transferring as a manager. They can be a specialized knowledge engineer, and we can transfer them over to the United States as a manager. And lastly, this visa is issued in total for 7 years, the L1A. So we would still apply for 3 years at a time, but it would be the total time would be 7 years. The L1B is for intra-company specialized knowledge positions. And you might be asking, what does that mean, specialized knowledge? The first point on here is the definition from the regulations, and just a little abbreviated. And it's basically that individual, whether it's an engineer at your company, a researcher, has special or advanced knowledge of your products, your processes, your techniques, but things that are very unique to your company. Because what's important when it comes to the specialized knowledge category is we do have to demonstrate how this individual is different, how they're special, how they're advanced compared to others in the industry, but also to an extent to individuals in your own company, and especially in the United States. So we have to show basically why it's this person that we want to bring along, versus, for example, hiring someone else or training up someone in the United States, why this person is so important. So for example, maybe they developed a process that has really improved the efficiency of a product development in let's say the Czech Republic or somewhere else. That could be a good way to demonstrate that they're special because they're the ones that developed this product. But one thing that's a little complicated at times when it comes to this visa is we can't just state that they have this special or advanced knowledge, and we can't just state it's of this product. We also have to provide corroborating evidence, and that can be things such as schematics. It could be PowerPoints of something, something that not just states it, but also demonstrates what this product is and why it's so unique. Anything that's provided does remain confidential, but it is something that USCIS has been seeking more and more. And again, there's no minimum degree requirement for this one, but there is that 1-year rule. I have written here unless a blanket L. So if you're coming in as a blanket and you go straight to the consulate, you do actually under an L1B have to show that you have a bachelor's degree at minimum. But even those companies that have that blanket L can still do individual petitions with USCIS for individuals who might not have that bachelor's degree. And unlike the L1A, the L1B is issued for a total of 5 years. So I know Mike mentioned that previously we were talking about the non-immigrant visas, which are those temporary visas, even though sometimes they're not temporary. We are moving now to the immigrant visas. And on this slide, we just wanted to generally show the permanent residence process. And usually it's a 3-step process. The first step is labor certification, which is a recruitment process showing that there's no qualified or eligible US workers for the position. The second step is the immigrant petition, which is basically the actual visa, your spot in line. And the last one is the adjustment of status or consular processing. And why we wanted to show this is because in most of the visas that we'll be discussing for those high-skilled individuals, we actually get to skip step 1. And this is very important because step 1 currently is taking a very long time. And sometimes it's the biggest hurdle to jump through. So these categories are very nice. You get to skip step 1. And another benefit is when it comes to step 3, a lot of them, there's a lesser waiting period to actually obtain that green card. So that's why we wanted to show just the general process. So now we're moving on to the EB1, extraordinary ability. Mike spoke about this basically when he discussed the O1. It's very, very similar requirements. You have to show 3 out of those 10 eligibility requirements. You have to show that you're extraordinary in sciences, arts, education, business, athletics. So very similar to the O1. The biggest difference I would say is that it's a little bit higher of a standard, and you actually do not need an employer to petition for you. This is one of those visas that an individual can self-petition for. And the other benefit of it is you do get to skip that recruitment process that some green card holders have to go through. And another thing that's very nice about this visa, at the moment, it is current for most individuals from most countries, which means that aside from processing times, there's no delay in obtaining this one if you qualify. An EB-1B for outstanding professors or researchers follows very similar to the EB-1A, the O-1, but it's specific for professors and researchers. You have to meet 2 out of 6 requirements. They're a little bit different, but for the most part, they're very similar to the EB-1A. And in addition, you have to be coming into the United States. So you do need a job offer because you have to be coming into the United States for a tenure track teaching or research position. And the employer, although they don't have to do that recruitment process, they do have to show that they have accomplishments in the field that you're coming in, and also that they employ at least 3 full-time researchers. So the individual that you're hiring can't be the first researcher that you're hiring in this field. But otherwise, very similar to the EB-1A, also an expedited process when it comes to getting the green card. An EB-1C, multinational manager, the next slide, very, very similar to the L-1A visa. So same thing, personnel managers, functional managers, executives, no degree requirement. The biggest difference between the L-1A and the EB-1C is I mentioned with the L-1A that you can transfer someone as a specialized knowledge position into a manager position. That's not the case with the EB-1C. This is for individuals who are managers at your entity abroad or executives at your entity abroad and are coming in as managers or as executives. But also no wait times, no recruitment requirements. So very nice visa for your higher ups to obtain a green card.
And then the last immigrant visa category that we wanted to share with you is one called the National Interest Waiver. And that's designed as sort of that broader category I was talking about earlier, which is if you have an individual that we can demonstrate is coming to the United States to engage in work that is in the national interest, meaning that it's important work, that it will apply nationally, and will be a benefit to the United States altogether, there is a dedicated immigrant visa available for those folks that we can take advantage of. It's a great way to go because, like Ewelina said, we get to skip that first step. We don't have to show that there is a lack of qualified U.S. workers for somebody to become a permanent resident based on national interest waiver. We just show that the work that they're doing, we would all benefit here in the States if that work was being done here in the States. And they essentially get to skip pretty close to the front of the line, which is great. And it's in tune with the overall policy on our immigration system, which is our system protects jobs for U.S. workers that do not require, that either are engaged in physical labor or do not require any advanced degrees. But it makes it easier to hire foreign nationals when you get to the other end of that spectrum, where you have somebody here who, the best example, or at least the one that we engage in most of the time, is with research scientists. When we can show that they're going to conduct research in the United States that benefits the United States, they have a straightforward path towards becoming a permanent resident. It's not limited to research scientists at all. Frankly, this can apply in any field. We've received national interest waivers for athletic coaches, engineers of a lot of different types. It's just a matter of being able to demonstrate what it is that they're doing and how we as a country would benefit from them doing it here. The last piece before I answer a couple of questions is the visa bulletin. What the visa bulletin is the Department of State provides a notice to us and tells us which applications they are working on, and when, as Ewelina referred to earlier, you get a priority date, how long it's going to take you to become be eligible to become a permanent resident in the United States. And you can see that employment-based category all the way on the left, the first category, which is the EB-1, everywhere around the world is current, meaning if you can get through, if you can make that application and show that you are qualified, that the employer is eligible, and you meet those requirements, you can apply to become a permanent resident immediately. If you are in some of the lower categories, EB2, which is available to those folks who have either a master's degree or a bachelor's degree and 5 years of experience, There is higher demand for those because, of course, there are more folks who have those qualifications. They're only working on those applications that were filed on or before February 15th of 2023. And it sort of goes down from there, where we get significant demand from particular countries. They get their own visa bulletin dates. So there's a lot of demand, as you might guess, from those folks born in China, India, Mexico, and the Philippines. And the delays can be significant. If you look at the EB2 category for those born in China, they're working on applications filed on or before June 1st of 2020. So that just relates to the timing issue, because as I said at the beginning, so much of this, almost all this can be done. Can it be done in a time frame that accomplishes what it is that you all are trying to accomplish? Meaning, can we do it in a meaningful time that gets people here and gets them to work on the projects that we need done in any meaningful amount of time? Sometimes, unfortunately, the answer to that is no. Oftentimes, there are options to get people here, and then we work on the longer range plans to keep them here. We're about out of time, but I saw that we had two questions, one that would apply to any type of visa. The question was, what type of agreement can we enter into with a foreign national to repay any of our costs if they leave the company after some period of time? You can get different opinions on this, but my opinion is this, that we can have foreign nationals enter into repayment agreements that obligate them to stay for a period of time, or reimburse the employer for the costs that they incur in obtaining these visas. The last thing you would want to have happen is to invest the time, money, and effort to get somebody a permanent resident card and then have them leave immediately after that. It doesn't happen a lot, but it does happen. And we can enter into those agreements to at least make them think about repaying our costs if we have a significant investment. The other question that I wanted to answer, because I think it ties into a lot of this, is somebody asked, we have an a candidate in Mexico that we want to move to the United States. There are actually specific visas that are available to our friends from Mexico and Canada. They came through NAFTA, of course. And so if you have something like that, or something that feels like it doesn't fit perfectly into any of the categories that we just talked about, shoot us an email, give us a call. Oftentimes there is going to be some visa available that's going to let us accomplish what it is you're trying to accomplish, but it doesn't take long for us to figure out, with some basic information about who the person is, what their qualifications are, and what the job opportunity is in the United States, to figure out what the best visa option is for you. So that is definitely all of the time we had set aside for this. If you submitted a question in the Q&A or the chat that we didn't answer, we'll get it back to you. Thank you so much for joining us today. Have a great day.